Hello, this is R.J. Deacon reading the Supreme Court of the United States opinion syllabus in Ford Motor Company versus Montana 8th Judicial District Court. Certiorari to the Supreme Court of Montana. Argued October 7th, 2020. Decided March 25th, 2021. If you'd like to support the podcast, please stay tuned to the end of the podcast. Ford Motor Company is a global auto company incorporated in Delaware and headquartered in Michigan. Ford markets, sells, and services its products across the United States and overseas. The company also encourages a resale market for its vehicles. In each of these two cases, a state court exercised jurisdiction over Ford in a products liability suit stemming from a car accident that injured a resident in the state. The first suit alleged that a 1996 Ford Explorer had malfunctioned, killing Markaya Gullett near her home in Montana. In the second suit, Adam Bandemir claimed that he was injured in a collision on a Minnesota road driving a defective 1994 Crown Victoria. Ford moved to dismiss both suits for lack of personal jurisdiction. It argued that each state court had jurisdiction only if the company's conduct in state had given rise to the plaintiff's claims, and that causal link existed, according to Ford, only if the company had designated, manufactured, or sold in the state the particular vehicle involved in the accident. In neither suit could the plaintiff make that showing. The vehicles were designated and designed and manufactured elsewhere, and the company had originally sold the cars at issue outside the forum states. Only later resales and relocations by consumers had brought the vehicles to Montana and Minnesota. Both states' Supreme Courts rejected Ford's argument. Each held that the company's activities in the state had the needed connection to the plaintiff's allegations that a defective Ford caused in-state injury. The Supreme Court held, a decision below is affirmed, and Justice Kagan delivered the opinion of the court. The connection between the plaintiff's claims and Ford's activities in the forum states is close enough to support specific jurisdiction. The 14th Amendment's Due Process Clause limits a state court's power to exercise jurisdiction over a defendant. The canonical decision in this area remains International Shoe versus Washington. There, the court held that a tribunal's authority depends on the defendants having such contacts with the forum state that the maintenance of the suit is reasonable and does not offend traditional notions of fair play and substantial justice. In applying that formulation, the court has long focused on the nature and extent of the defendant's relationship to the forum state. That was Bristol-Myers Squibb versus Superior Court of California. That focus has led to the recognition of two types of personal jurisdiction, general and specific jurisdiction. A state court may exercise general jurisdiction only when a defendant is essentially at home in the state. That's Goodyear Dunlap Tire Operations SA versus Brown. Specific jurisdiction covers defendants less intimately connected with the state, but only as to a narrower class of claims. To be subject to that kind of jurisdiction, the defendant must take some act by which it purposefully avails itself of the privilege of conducting activities within the forum state. That's Hansen versus Denkla. And the plaintiff's claims must arise out of or relate to the defendant's contacts with the forum. That's Bristol-Myers again. Ford admits that it has purposefully availed itself of the privilege of conducting activities in both states. That's Hansen. The company's claim is instead that those activities are insufficiently connected to the suits. In Ford's view, due process requires a causal link locating jurisdiction only in the state where Ford sold the car in question or the states where Ford designated and manufactured the vehicle. And because none of those things occurred in Montana or Minnesota, those state courts have no power over these cases. Ford's causation-only approach finds no support in this court's requirement of a connection between a plaintiff's suit and a defendant's activities. It's Bristol-Myers. The most common formulation of that rule demands that the suit arise out of or relate to the defendant's contacts within the forum. The second half of that formulation, following the word or, extends beyond causality. So the inquiry is not over if a causal test would put jurisdiction elsewhere. Another state's courts may yet have jurisdiction because of a non-causal affiliation between the forum and the underlying controversy, principally an activity or an occurrence involving the defendant that takes place within the state's borders. And this court has stated that specific jurisdiction attaches in cases identical to this one when a company cultivates a market for a product in the forum state and the product malfunctions there. See Worldwide Volkswagen Corporation versus Woodson. Here, Ford advertises and markets its vehicles in Montana and Minnesota, including the 2 models that allegedly malfunctioned in those states. Apart from sales, the company works hard to foster ongoing connections to its cars' owners. All this Montana and Minnesota-based conduct relates to the claims in these cases, bought by state residents in state courts. Put slightly differently, because Ford had systematically served a market in Montana and Minnesota for the very vehicles that the plaintiff alleged malfunctioned and injured them in those states, there is a strong relationship among the defendant, the forum, and the litigation. The essential foundation of specific jurisdiction. That's Helicopteros Nacionales de Colombia S.A. versus Hall. Allowing jurisdiction in these circumstances both treats Ford fairly and serves principles of interstate federalism. It's Worldwide Volkswagen. Bristol-Myers and Walden versus Fiore reinforce all that the court has said about why Montana and Minnesota's courts may decide these cases. In Bristol-Myers, the court found jurisdiction improper because the forum state and the defendant's activities there lacked any connection to the plaintiff's claims. That is not true of these cases, where the plaintiffs are residents of the forum states, used the allegedly defective products in the forum states, and suffered injuries when those products malfunctioned there. And Walden does not show, as Ford claims, that a plaintiff's residence and place of injury can never support jurisdiction. The defendant in Walden had never formed any contact with the forum state. Ford, by contrast, has a host of forum connections. The place of a plaintiff's injury and residence may be relevant in assessing the link between those connections and the plaintiff's suit. The decision below is affirmed. Justice Kagan delivered the opinion of the court, in which Chief Justice Roberts and Justices Breyer, Sotomayor, Kavanaugh joined, and Justice Alito filed an opinion concurring in the judgment. Justice Gorsuch filed an opinion concurring in the judgment, in which Justice Thomas joined, and Justice Barrett took no part in the consideration or decision of the cases. To support the podcast or support me as I work through law school, please find the podcast on Patreon or follow the PayPal link in the show notes. If you'd like to get a hold of me, I can be reached at rhodesscholar80@gmail.com. And I'll just put a little note in the end here that I did actually sell Fords in Montana for 3 months.